Good afternoon, everybody, and thanks again for logging in to the Strategy Stacker on iTunes, the podcast where we talk about all things financial in conjunction with the radio show on 2CC at 4:30 on a Friday afternoon. Today, we're lucky enough to have Mark Poretti from Trinity Law with us, and we thought it quite timely to talk about the benefits of a will, and also then moving into talking about enduring powers of attorney, which are two things that I get asked about regularly that obviously we don't do, but we outsource to a professional. So Mark's going to tell us a little bit about what they do in their firm, and then we're going to get into those two aspects of your estate planning that'll then dovetail into conversations around personal matters and also directors and structures and companies and different entities that people may use in relation to their investments or their business operations. And then we can touch on the benefits of things like a testamentary trust, which I may need if my children keep screaming in the background. So without further ado, Mark, thanks so much for your time today, mate. Really appreciate it.
G'day, Luke. Thanks for the invitation to come on board, mate, and have a bit of a chat. Firstly, I guess in relation to what we do, what I do, working at Trinity Law, I'm the partner in charge of the small to medium enterprise area. And as part of that, I just look after businesses. I look after a little bit of commercial property. Yep. And I do a fair bit of estate planning, business succession, which includes your wills and enduring powers of attorney. Yep. We've got a commercial partner here, John, who looks after a lot of unit developments and a lot of general commercial work. We've got a litigation team with Morris and also private client with Michael. We're essentially an all-round commercial law firm with the only thing is we don't do our family law and criminal law.
Right. Okay. Well, as I say, you've got sort of specialists in all areas, because I found that, you can take on most things and have somebody that's right up on what's going on. And as you say, you've got Mr. Property in John Irvine as well. So
exactly right.
Okay. Well, I think this is quite timely because some of the discussions I have with clients around obviously their structures, be it investment, be it super, and obviously then the use of companies and trusts, I think it dovetails in quite well because this is quite a specialised area, and I don't think it gets the technical recognition that it should, because a lot of people just say, oh, it's just a will, things go from here to there. But, there's obviously some key elements that form the writing of a will and bringing this sort of document to life. Just want to touch on some of the key elements that obviously you look at and address with clients to make sure that all their bases are covered and they have a better understanding of what the document actually does for them.
Yeah, sure, absolutely. One of the things actually that was brought to my attention this morning, just in relation to the wills. Firstly, the wills are governed by each state's and territory's legislation. And part of the intricacies of preparing a will is how it's executed. So there are some fairly strict witnessing requirements in order to be able to administer a will or for a will to be effective. Those are in the process of changing with reference to COVID-19. So as part of the executing a will, New South Wales has just come out and passed legislation to say that you don't actually have to be physically present with someone who's making their will in order to witness it. And in fact, they'd be satisfied with an audio witnessing, provided that the person who did the witnessing used reasonable endeavours to satisfy themselves that the person on the other end of the phone was executing the same document that the witness was looking at. Then the witness can subsequently witness a copy, and that will be deemed to be an effective will for the purposes of administering a will when that person dies. Now, ACT hasn't yet followed suit on that. And in fact, it was only probably a week and a half ago where they came out and said that they weren't going to be changing the requirements. But now that New South Wales has, as ACT sometimes does, they might well follow suit with that.
Pretty big change, isn't it?
Pardon?
Pretty big change like that.
It is. It's very significant. But, we are kind of in the times of significant change at the moment. And I'm surprised that, the law only took 4 or 5 weeks to come up to speed. Usually it's a matter of years.
Yeah, quite surprising.
Yeah, exactly right. Now, the question was about some things to consider when drafting will. Is that right?
Yeah, that's right. So if we sort of break it down, if maybe we start at the top and say, look, what's the executor, who's the executor, and what's their role in the document?
Yeah, sure. So the executor, is the person that is appointed by the testator or the person making the will, that will administer the provisions of the will once the person dies. So the executor is the one that has the power to call in all the assets, distribute all the assets in accordance with the provisions of the will. Now, it's quite a fair bit of responsibility on the executor. Firstly, in order to satisfy, I guess, the provisions, order to carry out the intentions of the person making the will, the executor needs to make an application to the Supreme Court for probate to be granted. Now, probate is the Supreme Court saying, yes, stamping it, the executor now has power to deal with the assets of the deceased and to distribute them in accordance with the will. It's quite a significant process with affidavits and applications and requirements such as advertising that the person is deceased before approving the probate. It is significant, but in practicality, it isn't for the executor. The executor, all they need to know really is where they find the will and which lawyer to turn to. They then essentially give the will to the lawyer saying, I'm named as the executor, what do I do? The lawyer then go ahead and make all the relevant applications with the help of the executor to make sure that it's as simple a process as possible. Obviously, the executor is going to be someone that's very close to the person that made the will, and so it'll be a pretty difficult time. So part of the solicitor's role is to make it as simple and pain-free as possible. So really, that person should be someone that's trusted, should be someone that's close to the person making the will, and it is always important to have a fallback. So a will is often made, and this is one of the problems with a post office will. A will is often made with the intentions of the person making the will or the circumstances that exist at the time. So right now, I might say, right, I appoint my wife as my executor. Now, in 10 years, right, if I die, she might already be dead, in which case the will doesn't work because there's not another executor. So it's always good to have a fallback executor just in case the first person you appoint is no longer around. That's one of the key considerations. They need to be trusted people in your life at the moment.
Okay, and when you touch on probate there, is there anything that triggers probate? Is that done on the value of the assets? Is it a mandatory thing? Is it a state-based thing? Is there some wills that don't require probate? And if they did, what would that sort of situation look like?
Not really. Usually when, if there's no significant assets in the estate or assets that require technical transfers, then you might be able to do it without, but it's always advisable to get probate just to make sure the Supreme Court stamps it and says, yes, you have the power to deal with it. The thing about wills, and which we might touch on a little bit later, is that they are easily challenged by people that might have an interest in the estate. So the last thing the executor wants is a challenge to their distribution of the assets, for that all of a sudden end up in court, and the court says, why didn't you obtain probate in order to have the power to deal with the estate effectively? Then that becomes a problem. If the executor does the wrong thing, then it is a problem for the executor. They are, I guess, liable for any things that they do that are against the provisions of the will or aren't in the best interests of the estate. So it is important that they act with those responsibilities in mind.
And when it comes to we talked about collecting all of the assets and understanding what the pool of distribution of assets are. Is there any time frame is there anything that's mandatory in relation to waiting a period of time? Obviously, the probate's done, it's advertised, and then it's stamped by the court, and the executor can then step in and say, okay, Auntie Jenny said A, B, C, D, and E, and then they can execute that immediately? Or is there a time frame that's applicable in relation to someone passing and then the executor being able to pull the trigger on the wishes of the person that's passed?
No, there isn't. You can make the application for probate as soon as you can, really. But as part of that application, what sometimes slows the process is dealing with the third parties where the assets might be held. For example, dealing with share registries or dealing with banks in relation to finding out how much was in the account at a certain point in time. That all needs to happen. And as part of the application, you essentially need to put a schedule of assets into the application so the court knows exactly what assets are going to be dealt with.
Right.
When it's being administered. So no time frame, just as soon as possible.
And if the assets are held jointly, for example, the person that is acting in that role then becomes the owner/controller of that asset to then follow out the wishes in the will?
If an asset is held jointly, do you mean?
Yeah.
No. So let's talk about the family home. That's usually a big one. There's two ways that two people, husband and wife for all intents and purposes, can own the family home. It can be owned jointly, where it's actually on title as being owned jointly, or it can be owned as tenants in common. If the house is owned jointly and one of the joint owners dies, then the house automatically, upon lodgement of the appropriate form, transfers to the surviving person. So that asset doesn't form part of the deceased's estate. If, however, they own 50% as tenants in common, then that 50% does fall into the estate and is distributed in accordance with the will. So when you're buying your house, it is important to answer that question, do you want to own it jointly or as tenants in common, bearing in mind what happens when you die.
Yeah, look, exactly, because that then obviously you have an equitable interest in an asset that obviously you then have to go into discussions with the co-owner to be able to say, well, there's a commercial value to whatever's being held, and the executor needs to pass that out. It could be sold on the open market. It could be bought by the person that owns it, tenant in common. There, some of the strategies and technicalities that the executor would walk into. So as you say, having somebody that understands and has the skill set to be able to do this in conjunction with some professional advice can become very important when talking about significant assets.
Oh, absolutely. Yeah, very important to make sure that the T's are crossed and the I's are dotted when you are distributing the assets.
Okay, unreal. So if we then move on to saying, well, in most situations where there are children involved, what does a will allow you to do in relation to the protection or the guardianship of kids where they may be minors involved?
Yep. So if there are minor children involved, sorry, the lights have just gone out because I haven't moved. If there are minor children involved, what you can do through your will, if there is no other parent around, is you can appoint a guardian of your minor children. So similar to the executor, choose a trusted person, have a guardian appointed, and then have a fallback guardian just in case the first mentioned guardian is no longer around. That sort of starts to tie in also with where you leave your assets, which if you die with minor children, if there's no other parents around. One of the key things to consider is who's going to be in control of those assets when you do die. So essentially what you can do is leave the assets to your children, but on trust.
Mm-hmm.
That's the trust when it's created by a will is called a testamentary trust. And through your will, you appoint a trustee of that trust. So it might be that I leave my estate to be split evenly between my two kids, and I'm appointing my sister as trustee of each of their testamentary trusts to hold half of the value of the estate each. My sister would then hold or control that asset for each of those children. Through your will, you can then dictate, well, at what point will you be comfortable in your child turning around to the trustee and saying, dear dad's sister, I'm now 21 years of age. I want the assets. I don't want you to hold it anymore. I want it in my name. Or I'm now 25 years of age. You set the age limit. So whatever you're comfortable with, then they can turn around and do it. The alternative is they can then say, look, I'm kicking you out as trustee. I'll be the trustee. And that child can then use that testamentary trust as an investment vehicle moving forward should the need arise.
Yeah, and one of the big, that's great that you've led that, because that's exactly where there was one of the next things I wanted to talk about, because from an investment standpoint, for those out there that haven't been exposed to a testamentary trust where minors are involved, one of the major benefits of using a testamentary trust is not just the asset protection where, someone who has the capability to manage a portfolio or an asset that's passed to minor children, but also that children under the age of 18 can actually receive income distributions using adult marginal tax rates. Now, that doesn't sound like much, but when you consider the tax impost of earnings for a minor get very, very expensive from a tax standpoint very, very quickly, it is a very, very powerful structure that can actually allow the children to, for example, as you say, you pass an asset into a trust, there's a house in there, the house is rented. If you've got two children, you could receive $18,000 of income each before income tax is paid. Now, if we think about the purpose of most assets as a parent, we're collecting assets along our lifetime to pass to our children, and they can maximise the rent from a house or the dividends from shares to then fund school fees, living costs, and other investment opportunities. The power of a testamentary trust is one of those things that is significantly underestimated, and I find not utilised to the extent that it should be, because, again, there's that general assumption when I meet people that, oh, this is pretty straightforward, it's just a will. And as I say regularly on the show, you don't know what you don't know.
Exactly right, and they can be useful tools. I mean, one of the things that you started touching on was a testamentary trust, I guess, for the purposes of asset protection. Just to clarify as well, a testamentary trust can be used for adults. They're not necessarily just for minors. So it might be, for example, my wife might have a high risk job. Okay, so the last thing, or she might be in a top tax bracket. The last thing I would want to do is either burden her with an asset, which all of a sudden becomes an at-risk asset if it's left to her in her name. And then then you sort of have to have considerations in relation to transferring it out of her name, for example, stamp duty if it's property or some other tax requirements. But the other thing is I don't want that asset to be at risk should she get sued because of a high risk job. So if you leave it in a testamentary trust, she can be the trustee of that trust. It's on trust for her, but it is outside of her, I guess, beneficial ownership for the immediate term.
Yeah, and I think that's a really important point to make, is there's a significant difference in the eyes of the law between your beneficial interest in something and your potential ownership in something. And I think that's a great distinction to make, because there are jobs that obviously do carry high amounts of litigation. And as I say, from an asset transfer perspective, you may want to protect assets from a third party, et cetera, et cetera. So I think, the drafting of a good will here is a lot more complicated than people think. And it really is something that specialised advice can make a huge difference with. Now, it's not so much your problem, because a lot of people say to me, well, I'm dead, it's not my problem. But if you have ever been in the position where you've acted in the executor's capacity, it's a huge undertaking. Having done it myself once before, it is quite daunting, because obviously you are seeking advice from a professional, but also that you have a huge amount of responsibility to the people that have been named in the loved one that you've known. As you say, because in a lot of instances, people do trust, they use their trusted confidant. What if somebody wanted to give specific things to people? Say, your wife had a necklace that she wanted to give to one daughter and not another. Is that something that can be specified in detail in a will?
Yeah, absolutely it is. So you can leave whatever assets to whoever you like in your will. So you can do it by way of, I'll leave my whole estate to whoever, this person, or you can do, so, firstly, I'll leave the following specific gifts. So it might be, I'll leave my BMW to my lawyer, Mark Poretti, as an example. Or it might be, I'll leave a particular piece of jewellery to my daughter. List as many as you like. There's no limitation on that. And then you can break up the residue of your estate however you like as well. It really doesn't matter. One thing for consideration, however, is the ability of any interested party to challenge the provisions of the will.
Right.
So what I mean by that is a potential or a family provisions claim. A family provisions claim is a claim made by an eligible person against the estate on the basis that they should be entitled to more, realistically. To be an eligible person, it's a very low bar. So really, you just need to have some connection or nexus with the deceased person to be an eligible person. You can then engage a lawyer, commence proceedings, and start the family provisions claim. The thing about the claims are that the costs of the claimant are paid by the estate. So the easier it is for someone to challenge, okay, the more likely they are to do so, and the more the estate will be whittled down, paying the costs of the claimant to either fight it or satisfy it. The point of that is, when you're drafting a will, one of your considerations must be, is there anyone that I'm either leaving out or not giving them enough, where they might consider that they're entitled to more. Right. The way that that's sometimes dealt with in a will can be done a number of ways, and it might be that you give them a token amount in the will. If you don't want to give them anything, just say, or you put a specific line of consider this person, I don't want to leave them anything. Just so it is clear to anyone looking at the will that you have considered that person, you don't want to give them anything. If you had just simply left them out of a will, then it might be that their argument will be they forgot about me. This is everything that we've done together. This is how much I relied on the deceased. Therefore, I should have a little bit more provision. It just has to be considered and then dealt with in the will or a letter attached to the will in order to limit a potential liability under a family provisions claim.
And again, another good example of why a cookie cutter option out of a post office would miss these sorts of intricacies and potentially open up. Whilst you saved a few dollars drawing the document up, you could have incurred huge additional legal fees or a loss to the overall estate through a challenge, through something being inefficiently worded. That could have been taken into account right at the start, and it could have been a lot more appropriate.
And I just want to have just to outline, I guess, the importance of having a will at all in terms of what happens if you die without one. So I'll never forget one of the first matters that I had to work with. So when there is no will, an interested person or a person that would be qualified to be the executor or can actually make an application to become the administrator of the estate. So just a change of terminology. And then letters of administration of the estate are granted by the Supreme Court. Similar to probate, a few more hurdles to jump through, but essentially has the same effect. That person then has the power to deal with the estate or the assets of the deceased. However, under the will, obviously you give direction and you sort of set out how you want the assets distributed. Without a will, there's no way of knowing. So in the Administration of Probate Act in the ACT, it's set out in a schedule what happens. So it actually says, and I've got to print it out just in case, if there's no children, regardless of whether they're minor, then the spouse gets everything. Where there are children, if the value of the estate is over $200,000, the spouse gets $200,000, and then if there's one child, half of the rest. If there's more than one child, 1/3 of the rest. So if I died without a will, okay, and my estate was over $200,000, my wife would get $200,000 and then 1/3 of the balance. Now you think about that practically moving forward in terms of my wife wanting to sell the house and move on. Well, if half the house is in my name, tenants in common for the sake of argument, so it went in accordance with my will, then she would only get 1/3 of that. And the rest would have to be held on trust for my kids. Now, there is potential to be able to deal with that, but there always have to be a record. There'd have to be a trustee that looks after the kids. And there would have to be a lot of admin to make sure that the obligations of the administrator are satisfied in terms of looking out for the best interests of the children. So it does get quite complicated. And it also has the detrimental effect of my spouse not being able to deal with 100% of the assets or own 100% of my assets for her benefit.
And again, another example of a poorly worded document up the front causing much bigger unknown problems down the road, and just a lack of attention to detail. Because I find often I'll speak with clients and, have you got a will? Oh, yeah, I've been meaning to do that since the kids were born. Oh, how old are the kids? Oh, they're 35 and 40. Yeah. So it's for me, as an advisor, it's one of those things that people are meaning to get to, and we make a concerted effort to try and, I guess, either plug that hole and get somebody in to do it, or just if we're going to be going through the process of signing some forms and doing things, let's wrap all our incomplete or incomplete admin up at the same time and get something in place for exactly those reasons. Now, let's talk then about business operations. So you and I are in business. We may have shares in a company. We may use a trust structure, et cetera, Let's just touch on some of the importance that you self-employed people need to keep in mind when it comes to structuring shares in an entity or trading companies and things like that.
So business can be owned a number of ways, and it might be that, actually before we go there, one of the other things that you can do in a will, just in relation to a structure, is give someone a power of appointment, or your power of appointment.
Right.
Sometimes in a structure, you might personally be, or testator might be the trustee of a trust. So it might be Mark Poretti as trustee for the Porreti Family Trust. Okay.
Mm-hmm.
If I die, there's no trustee, and that becomes a problem. So what you can do through your will is give someone else power of appointment, which is essentially you saying, where I am personally the trustee of a trust, this person will be my trustee in my place when I die.
Right.
That just deals with it so easily. Everyone moves on. There's then other considerations about who you're going to appoint and what they'll then do with the assets of the trust, because the assets of the trust will fall outside the will. That's a whole conversation which we probably don't have time for today. In relation to business structures, however, it becomes very important to consider those when you're preparing a will, particularly in relation to the distribution of gifts. So if you and I were in business, we had a company, we both own shares in the company, all right? My will might say, I leave everything to my wife, okay? I die, all of a sudden my wife owns half of the business. Now, you've met my wife, you probably don't want to be in business with her. And likewise her with you, nor would she know anything about whatever the business is that we conducted. So it just doesn't work on a whole lot of levels.
Yeah.
You then start looking at issues like, Mark's dead. He's worked for 20 years getting this business together, building the goodwill. It's got value, right? How do I now force Luke to pay what it's worth so that the estate gets value and my wife can move on with her life, all right? It's an incredibly complicated and difficult situation because there is no way without an appropriate agreement between the two shareholders about how to extract that value from the estate. So it is a huge consideration. That usually turns into a conversation about a shareholders agreement. So where there is a business, let's get an agreement in place now before anyone dies about what happens should one of them die. What happens to the shares? What is the value we place on it so that value can be paid to the estate through an agreement, signed prior. That is critical. And what you do in a will to cover off on a business structure differs with every structure and with every business. So again, it is of critical importance to recognise that and to talk to someone about what your existing structure is at the time of creating a will so that you do minimise the issues later on. Like you said before, while it might not be your problem when you go, I would suggest that if you're leaving a wife and kids behind, the last thing you want is your estate to be eaten by legal costs in dealing with the issues that you could have dealt with so easily before you died.
Yeah, and I think that's a really good point you've made there, because I know one of the things that we encounter, especially on the protection side of things, is that discussion around, well, what is it worth? And having that discussion with the shareholders in that business, because as you said, your blood, sweat and tears and what you would like to pass on may or may not be the market value at the time that you pass. And obviously trying to prevent that fire sale environment or a third party coming involved where the spouse has received the shares in the business and she doesn't understand how to value that particular industry or whatever we were in business doing. She could also then be influenced by somebody that could put unrealistic expectations on the business itself and the surviving shareholder. And that's where, your life contracts and your buy-sell contracts and those sorts of things are a way of creating that funding mechanism to take the financial burden off the business. But again, if you're not having these discussions in the will, it's not then triggering other considerations that, as you say, when somebody passes, we don't want to then put a huge amount of pressure on somebody that's just lost a loved one, or potentially not address, maybe a capital gain on the event of the sale of the shares in the business, and having the appropriate documentation to transfer and control what could have been, your third or fourth child. Because as most self-employed people know, it becomes one of your children. You love it and you nurture it and you water it and you grow it, and it has huge significance in your life. And I think this is why this conversation is so important, because people generally, I find, go, oh, it's just a will. It's so much more than that. And there are so many, tentacles that come off different discussions that may or may not have been considered, that, as you say, appropriately worded document at the start can take a huge amount of angst away from the people that have to manage it when you're gone.
So the first part of the conversation about preparing a will with a decent lawyer, it should be just a fact-finding exercise. So it should be tell us about yourself. What assets do you have? How do you own your house? Superannuation is a good one, which we haven't touched on, which we probably should. Just so that when preparing a will, the lawyer can sort of talk to you about the relevant considerations given your circumstances. For people that do this all day in, day out, it's a simple process. For a person coming in asking for a will and having never done one, it will be, not overwhelming is the wrong word, but it will be a lot of information to take in. And you just have to rely on the guidance that's offered by the professional that's looking after you.
And I think that's where you add your greatest value. You know, as I say, you don't know what you don't know. And these sorts of discussions lead down a path, you know, depending on a yes or no answer. Do I have a structure? Do I not? Do I have children? Do I not? Do I have existing business entities, et cetera, et cetera? So I think that's the greatest value in someone coming to see a professional, is that they can open your eyes to the things that you may not have considered that could be significant in relation to control, could be significant in relation to potential tax. It could be significant in relation to, you know, what happens to, you know, me if I don't have this document, as you touched on with, you know, the state-based rules that apply. But let's circle back around then to the super conversation. Obviously, we do a lot in that space, and it's obviously something that is another misnomer. Oh, I don't need one of those. It's covered in my will. When in actual fact, your super has nothing to do with your will, does it?
No, it doesn't. So a lot of the time, it's up to the trustee of the super fund to pay the super in accordance with, I think we had a conversation about this, but in accordance with a binding nomination, if there's one made, or alternatively, where they think it should go. Usually that might be the estate, and it might be paid into the estate as part of that, and in which case it should be in accordance with the will, and other times it might not be. So realistically, you need to have those two working in tandem, both your will and your superannuation, to make sure that it's the super is distributed to where you want it to go. So it needs to be a conversation with your advisor about super specifically, and how you've dealt with it, and how you want it to be dealt with when you die.
Yeah, I find that's a conversation that a lot of people haven't had at the same time. They've looked at the two different sides of this. Oh, this is my super, and here's where I want it to go, without considering the wording of their will, or they may not have a will and don't understand the difference, because a lot of people will come in and see me and go, oh, it's okay, I've got a will. I say, well, that's nice, but this has nothing to do with it. Unless you have a binding nomination that says it goes to your legal personal representative, and then it gets encompassed by what's documented in the will. But you could also use, as you've touched on, a binding nomination to have it paid to somebody else, so that it doesn't make it to the will and limits the potential for a challenge, as we touched on earlier. So it's really important, again, that your non-superannuation assets are addressed, and then obviously how you want superannuation to pass is considered, and some specific advice is brought up in that area, because some of the recent changes in legislation in relation to transfer balance cap, reversionary pensions, and obviously assets over 1.6 million can have some serious implications in relation to things that may need to leave the super world, that would then be encompassed by the will that you may have otherwise thought were wrapped up in super. So I think that's a really good point to make. Mate, that I think we sort of wrap that up in relation to, you know, the do's and don'ts in relation to a will. The next one that I get regularly is, I have an enduring power of attorney, it's in my will. And I liken that in a way to saying, well, I have a banana, and when I peel it open, there's an apple inside, which we all know isn't the case. So let's talk about, we've covered off what happens if you predecease somebody. Now, an enduring power of attorney is obviously a living, breathing document for when you're alive. So we just touch on the differences, and obviously the importance of what this document does for people.
Yeah, of course. So you're right. A will operates when you're dead. The power of attorney, enduring power of attorney, operates when you're alive, and when you can't make decisions for yourself, or when you nominate for it to commence. So enduring power of attorney is a relatively simple document, and it really has four main heads. What it does, it has you as the person granting the power of attorney, granting a person the power to make decisions on your behalf in relation to property, personal, health, and medical research. So And it's as general as that. It is, yep, I'll grant that person power to make decisions on those 4 areas. You can tailor it though. So you can say, yep, this person can have health and medical. This person over here, however, can have the other ones that I said. There's also the ability to put restrictions on it. So, for example, in relation to medical treatment, you might say, yep, this person can make decisions on medical treatment. However, they cannot make the decision to pull the plug if I'm on life support. So you can restrict that, or you just keep it completely unrestricted, and that your attorney then makes the decision as they see fit. Like the executor, like a trustee, it has to be someone that knows you intimately and knows your wishes in relation to that. So, one of the things that you might see is personal decisions. So personal decisions are things like where you live, what food you eat, okay? You might want to appoint an attorney to say they have the ability to make personal decisions. However, they cannot decide to put me in a home.
Right.
I've seen that. I've seen similar things like that where people think about the restrictions, or medical research. Yep, I'm happy for that person to make decisions in relation to medical research. So if I'm alive but not going to be coming out of a coma anytime soon, and they're going to pull the plug, they can donate my organs for medical research, except my eyes, because I want to keep my eyes. Sure. The financial is anything financial. So any assets that you have, any financial, your bank accounts, operating bank accounts to buy whatever you need, pay your bills if you've still got bills, all that sort of stuff, they can make those decisions. The personal ones we've touched on, where you live, what you do, other bits and pieces. But it's essentially granting someone the power to make decisions for you where a decision needs to be made.
And as you said, you can have multiple people doing that where they have different specializations. So you could have your wife making that choice in relation to what you eat and what you do, but you could have a trusted third party making financial decisions where they're controlling things in your best interest because they have that skill set where another person with the power of attorney may not have any experience in that area. So you can actually break it up and have different people at different times.
Yeah, absolutely you can. The alternative is you can also appoint 2 attorneys. You can appoint them jointly, so that where a decision needs to be made, they have to make it together.
Right.
You start to sort of get into areas where, doing what I do, I see problems, and one of my jobs is to always point out worst case scenario. So with this as an example, if you appoint 2 people, right? If you appoint one person, your wife for the personal stuff and a third party for the financials. If third party does something that my wife's not particularly happy with, there's going to be an argument. There's going to be a Barney. It's going to cost money. That's going to destroy a relationship there. It's going to be difficult to continue with that arrangement moving forward. So that has to be a consideration as well as to what you do. Quite often it'll be, I appoint my spouse as my attorney for everything. And then you're sort of relying on your spouse to obtain the appropriate advice that your spouse needs moving forward. The fallback then, like the executive, always appoint a fallback. You might say, I appoint my 2 kids jointly, in which case you say, great, they're joint, they make decisions jointly. And the reason that, I'd probably appoint the 2 kids rather than just one is because I don't want them to fight about decisions.
Oh, exactly. Yeah. Now, to act in that capacity, you have to be over the age of 18?
Certainly do, absolutely.
Okay. So that's the only the prerequisite is you're over the age of 18, obviously have the capacity to act in that role.
Absolutely.
And then make sure that, and again, another really good example, I know one that I had personally was my parents lived overseas for a number of years. So we had power of attorney to be able to talk to Telstra about the phone bill because it was in my dad's name at the time. So a power of attorney can be a really useful document for things that don't have to be really significant. It could be something like mum and dad have gone on a holiday and you need to sign a new lease agreement for a property they own.
Yep.
That could be a use of a property. It could be, if your wife likes ringing up Telstra and screaming at people, she can send through a power of attorney and the phone will be in my name and she can spend 3 hours screaming at them and that could be her pleasure for the day. But
there's a couple
the legal capacity to do that, to act as me because I've given her that power to do so.
There are a couple of, details to be aware of. The first one is at what point do you become the power of attorney? So at what point do you have the power to make those decisions? And it might not necessarily, depending on how you fill out your form, it might not be when you lose capacity. So you might instead elect to appoint that person immediately, right? And then you take your attorney, you stick it in the drawer, and you say, there it is, pull it out when I lose capacity, and you can go. The other way to do it is potentially say, when you lose capacity. That then needs to be qualified by independent medical person or doctor, as they're known, to say, yes, this person's lost capacity, power of attorney is now in effect. That's a slower process, but that's what most people go for. The other sort of detail is that when you're dealing with assets, a lot of the time, particularly when you're talking about land or when you're talking about bank accounts, either the land titles office or the banks will require the power of attorney to be registered. So it needs to be registered in the ACT Access Canberra. Once registered, you take that registration number, we'll ask your power of attorney to whoever needs to cite it. They'll see that it's registered and say, fine, away you go. So there are a couple of little steps
on a state-by-state basis where you say you might have, if you're living in the ACT, you might have the mandatory investment property in Queensland.
Yep.
I think that's a compulsory thing at the moment. You must have an investment property in Queensland. There can't be any houses left to buy in Queensland, and people in Queensland must be getting really upset because people on the ACT keep buying them. But in that example, does that then need to be registered in the ACT and in the state where the asset is to have power?
It does. Absolutely, it does. So it'll be sent up to the Queensland registration office, whatever that is, for registration, and then it'll be recognised and you'll have the power to deal with the asset.
Right. Okay. I think one of the biggest misconceptions I see is that people think this is a document for the elderly. And when I have conversations with people, do you have a will? Do you have an enduring power of attorney? And they go, well, I've got one for my mum. I said, well, that's nice, but do you have one for each other? And they go, well, no. So I think it's something that is of huge value and of huge importance at any age where you are controlling assets. And it's not something that, that it's just for the elderly because you've ended up in a hospital, for example.
Think about current circumstances with COVID-19. So if someone contracted it, they went downhill pretty fast, they slipped into a coma, who's going to make decisions for them when they're in the coma?
Yeah.
No one's got power to do it unless they've got power of attorney. It's that sort of simple example where you go, oh, yeah.
Yeah.
Who's going to talk to my bank? Oh, no one, because no one's got power to do it. Who's going to talk to who's going to make a decision about the medical treatment?
And another real good one, like we just touched on, what about my super? I need to get money out to do a renovation on my home. I need to start an income stream. I need some capital because I'm incurring medical costs. Superannuation isn't a joint asset. It's in an individual's name. You could be members of the same fund in like a self-managed super fund. But again, if somebody doesn't have permission to contact the trustee of the fund and say, hey, Mark needs $30,000 to put a ramp at the front of his house because he's now in a wheelchair, you've got everything locked up and tied up. And again, it's a level of complexity and admin issues that at a time you need it most, you want things to be clear, concise, and really flexible. And I think this is one of the most understated documents that I find, 8 out of 10 people that walk in my door won't have. And it's almost for me a mandatory. It's got to be done, especially when you're also in that super example, trustees of a fund. Obviously, you're a director of a company. Being able to control superannuation assets in your capacity as a trustee is essential.
There's probably a few documents in this pile, but these the wills and the power of attorney, two documents that sit in a pile of documents that they're such simple documents to do. They're relatively inexpensive. And if you don't do them, the cost to either you or your estate in dealing with the fallout is just not worth the risk.
No,
it really isn't. It's so much better to do it now, get it done, and not have the issue later on. It's like a shareholders agreement. I'll never forget. I had a client come to me and say, "Oh, we've got an issue. We started a company a few years ago. We said no to a quote $3,000 to do a shareholders agreement. We need to get out of it. Cost them $16,000. You know what I mean? Whereas a shareholders agreement would have just set it out very clearly. This is what happens if this happens, and it's just bang, 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 done, away.
And the other thing we can't stress enough here as well is the peace of mind and the mental health of the people that are affected, that have gone through whatever's caused either of these documents to be triggered. I don't think you can put a price on it. And look, there are some things in life that you can negotiate in relation to price. It could be a car, it could be a bike, it could be a range of things. But the value or the unknown value of what could happen in the event of either of these documents being used is just unbelievable. And that's why I thought this would be so important in light of, current events and a change of people's perception of what is the new normal. I think if people can take something out of this is, wow, what would you feel like if that happened to you? And also, do you have the paperwork in place? I likened it the other day in a meeting to a mobile phone. When you're out with the lads having a beer and your wife rings and says, can you come home? You just want to drop that phone in a beer. But if you run out of petrol halfway down the parkway and you can ring her and she comes and saves you a day, you're really happy that you've got the phone at that time. And I liken these two documents to exactly that. It's like the paper version of a mobile phone. You want to have it and not need it, than need it and not have it.
Absolutely. Yep, absolutely.
Mate, that's absolutely unbelievable. Listen, if people have queries and questions and want to sort of get a little bit more advice in relation to what to do, how can people reach out and get in touch with you?
Yeah, jump on the website, send me an email, give me a call. Mark Poretti at Trinity Law. Very easy. We're obviously still working, half the time at home, half the time in the office, but always contactable.
Right, fantastic. Listen, thanks so much for your time, mate. And we'll do the second part of this next week, and we'll touch base then.
Perfect. Thanks, Luke.
Thanks, buddy. See ya.